Okay, well, hello everyone, and welcome to LAW2021 Online Wills and Probate Shape the Debate with myself, Amanda Tice from the Solicitors Group. With me today is Professor Leslie King and James Beresford. In this live session, you can put your questions to Leslie and James and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted questions and any live questions you put to us. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the Solicitors Group for further information. A recording of today's live session will be sent out by email within the next few days, so keep an eye out for this as well. So moving on to introductions. First of all, Professor Leslie King. Leslie King is a leading professional author and lecturer in wills, probate and trusts. Leslie is a former member of the Law Society's Wills and Equity Committee and the Probate and Estates Committee of STEP, and an honorary member of the Association of Contentious Trust and Probate Specialists. She is also a professional development consultant at the University of Law and co-author of numerous books in the private client sector. As part of LAW2021 Online, Leslie's sessions have included wills drafted for cohabitees and statutory wills and gifts by attorneys and deputies. Then moving on to James. James Beresford is a lecturer specialising in wills drafting and estates administration matters, and also helps his clients deal with their legacy planning, providing a comprehensive and understandable solution. He is a wealth preservation specialist focusing on inheritance tax for high-profile individuals and advising business owners on succession planning. He has been presented with 2 Private Client Team of the Year trophies at the prestigious Manchester Legal Awards, and is the author of No Will, No Say, A Simple Guide to Wills and Estate Planning, published in 2017. And for us today, James has been presenting on the removal of personal representatives and common issues and negligence in wills drafting. So we'll get started addressing some of your pre-submitted questions. So first we're going to Leslie. So if doing a will for cohabiting couples, what do you need to say to make sure the will is non-conditional on the marriage civil partnership taking place?
Okay, one of the problems with cohabitees is that they may, of course, marry or form a civil partnership, in which case any existing will that they have is revoked, unless the will says this will is made in expectation of my marriage to X. Now, some will writers suggest, and I think this is quite a good idea, in fact, they suggest if you're doing wills for a cohabiting couple and they're intending to leave everything to the other, even if they haven't got an immediate intention of marrying, it's quite a good idea to put a statement in saying this will is made in expectation of my marriage to Fred or Frida, and I don't want it to be revoked if we get married. And I mean, one thing I always say to people is you often get clients who say, no, totally opposed to marriage formality. We don't want any of that. And then one of them's diagnosed with a terminal illness, and you work out, how much money they're going to save if they, formalize their relationship. So lots of good reasons for putting it in, because if they do decide to formalize their relationship when one of them's terminally ill, it's good if they don't have to then redo their wills. Now, the difficulty is that if you've done a will for a cohabiting couple and they don't intend to marry or form a civil partnership, and they don't, and one of them dies 25 years later, you've got this will that potentially says, I am expecting to marry Fred Bloggs. I leave everything to Fred Bloggs. Now, in fact, that is a perfectly valid will. There's never any implication that the will is conditional, but you can imagine in that situation, some of the family on the other side saying, hang on a minute, this will looks a bit dodgy to me. It says you were expecting to marry and you didn't. How can it be valid? So it's a good idea if you're making a will in those circumstances, you're putting in the expectation of marriage or civil partnership, just add in a very simple clause. I mean, it's a very long answer to a very short question, but the question was, what should that clause say? absolutely no magic to it. I mean, just say what you mean, which is this will is not conditional on the marriage or civil partnership actually taking place. You were nodding, James. Did you agree with that?
I do, and I think I agree. I think it's always best to put it in, not just for the slight bit of entertainment you get when one party looks at the other with the puppy-dog eyes. You know, it's that you can then tell and see the sweats and go, well, I'm not saying we're not going to get married. I think that bit of entertainment we need to get as lawyers, you know, something I quite like. But I agree, it should be something, you know, I would always advise the cohabiting court to put it in, you know, say it's not binding you to get married, but it's there just in case you do. And a few some clients don't want to pay you twice. Yeah, it'll save you money in the long run.
And I mean, just going back to the terminal illness point, I mean, I had that in my own family. My mother married my stepfather when they were both 90, not actually because of the IHT, but just because she didn't like going into hospital being introduced as my, you know, what's the word, partner just doesn't go down well with a 90-year-old. And I, of course, had not done their wills, you know, I am expecting to marry, because they had both said, you know, we've been married before, we're very happy as we are. So I did have to remake their wills. And, you know, it was frankly a bit of a pain. But there we are. Okay, I'm done.
Great, thank you. So moving on to James now. So do you think we should use a will questionnaire for our clients?
God, that's a good question. So, will questionnaires, I think these can be quite contentious, really. My own view is that will questionnaires are dangerous, especially if you are asking a client the sort of will they want. I've seen it at a previous firm where we did a lot of postal wills, and the questionnaire would be sent out, say, who you are, where do you come from, what's your family situation, what do you want to do with your will? You know, tick A for everything to go to your husband, wife, civil partner. Tick B if you want a flexible life interest trust. Tick C if you want a discretionary trust. And there would be a couple of lines of explanation, but really, you're asking people to decide on something that they don't know, and they don't know what they don't know. So I think they are dangerous because you know what people like. They'll go, oh, I want the most expensive, I want the best one. You know, I'll have a discretionary trust. I don't really know what it is. And as an aside, I think you can see that with some online will platforms as well. Again, I've seen these in practice where clients will click, oh, I'll have a flexible life interest trust, then dropping into a discretionary trust because I can. The option's there. So I think a will questionnaire where you are actually asking a client to decide what they want to do with the estate is dangerous, because they don't know what they can do, they don't know what they could do. I think as well, nowadays when we see more and more wills being challenged, if you are relying on a will questionnaire, there can be accusation about undue influence, there can be capacity questions. I think they do really raise more questions than answers for you. I can see why people do it, because wills, and I completely agree with this. I completely disagree with this state. Wills are seen as a cheap commodity. I completely disagree. I think people pay for what they get. You know, unfortunately, people are paying for the tangible product rather than the intangible product, which is your knowledge and experience. What I do think is useful, though, is a client questionnaire. Not a will questionnaire, but basically a client questionnaire whereby you can get the information before you meet with the client, basically who they are, the marital status, have they made any previous wills, and their assets, you know, have they got any children who have died, any disabled children, because what that enables you to do is prior to your meeting with the client, you'll be able to read that, disseminate it, go through it with the client at the meeting. You'll be able to base your questions around it, and then you would be able to provide the bespoke advice for their individual circumstances. So I think it's a slight difference on the theme. You know, will questionnaires, I think, are bad. A client questionnaire that enables you to get the information for you to be able to advise the client appropriately, I think they're good. So I think it's dangerous just relying on a will questionnaire. It'll do more harm than good.
Can I just say a couple of things on that? I totally agree, basically. The asking the client to fill in information about themselves, their family, their assets, really useful. But just as important is going through it with them afterwards, because people are so vague about what things mean. And, you know, there's a recent case where there was a problem with nieces and nephews. That's what the will said, but it turned out that after the death, what the chap had actually meant was my nieces and nephews and my wife's nieces and nephews. So really important. And things like stepchildren, you know, whether, you know, if you just put children, it doesn't include stepchildren. And when you're going through the will with somebody, I always say, unless it's an utterly bog standard family, I would draw a little family tree and show it to them and say, so have I got this right? These are the people that you want to have included. And the other thing which is quite useful is to find out, particularly in the case of an elderly person, who filled it in. Because there's one case I can think of, and name doesn't really matter, where there was an issue after the death about the elderly lady's capacity. And the solicitor said, well, she filled in her questionnaire really, you know, accurately. Of course, turned out afterwards she didn't fill it in at all. Her daughter did, who was the one who was taking under the will. So it is worth just checking who filled it in, so that when you're making a note, you don't write something which turns out to be absolutely wrong. Yeah,
I agree, Leslie. I think it's getting the information before the meeting for you to then go through it with the clients at the meeting. Obviously, by doing that, you're going through Banks and Goodfellows. You're ticking the boxes off, which protects you, but also protects the client.
Yeah. Okay, Amanda, I think we're on to the next one.
So this next one is for Leslie. So is there really no time limit within which a marriage has to take place if it states it is made in expectation of marriage?
Oh, so this is leading on from the one I dealt with before. No, there isn't a time limit. I mean, if you say in your will, I am making this in expectation of marriage, and you marry 20 years later, it's covered. I was saying this once, and somebody in the audience said, oh, are you sure that's right? Because I know there's a case that said that after 25 years, the judge said that was too long. And I thought, really, that seems most odd. And I thought, I don't know this case. Anyway, afterwards, I dredged around and found it. And it was true that there was a 25-year limit and a 25-year lapse, and the judge had said this will is not made in expectation of marriage. But that wasn't the whole story at all. The whole story was that when the chap made the will, well, first of all, it didn't include an express statement that it was made in expectation of marriage. So you were looking for some kind of spelling out from the terms of the will. He had left his estate to my wife, Sybil. But at the time he made the will, he was married to somebody else. So, you know, there was no possibility of Sybil actually being his wife or of him marrying her, because he was married to somebody else. So, you know, in fact, the first wife died and he did then marry Sybil. But the point was there was neither a statement of expectation, nor was it possible to spell out any sort of inference from the will, because he couldn't have been expecting to marry Sybil at the time. So the answer to the question is there really is no time limit, but it doesn't alter the fact, going back to the first question, I would still put in this will is not conditional on, and then you don't even have to have the conversation.
Yeah, that's great, thank you. And we're staying with you for this next one, Leslie. So if an interest in property is left into a discretionary trust and the surviving cohabitee is given a right to live there rent-free by the trustees within 2 years of the testator's
death.
This is, we were talking about this before, this is my lack of knowledge of the subject. Will this interest be automatically treated as an IPDI for tax under section 144?
Okay, I think we need a bit of background on this one. This is coming out of part of the talk that I did about property rights and wills. And people often ask me, what's the difference in inheritance tax terms between giving somebody a life interest in a trust, which happens to own a residence, or giving them a right to occupy the residence for a limited period or until they move out, you know, whatever. But the basic question is, what's the difference between a full life interest in a trust and having a right to occupy a property? And the short answer, which I gave in the webinar, if you've watched it, is that there is no difference in inheritance tax terms. Now, there might be a big difference in the actual extent of the rights that the individual has. If you merely have a right to occupy one particular property, that's what you've got. If you've got a life interest in a trust that owns a property, you're entitled to enjoy the property or the income from it. Now, if I give somebody a right to occupy a property for a year, in inheritance tax terms, I am giving them an immediate post-death interest in exactly the same way as if I had given them a life interest to all of my property. If you do it in a will, you are creating an immediate post-death interest. So if I gave somebody a right to occupy my residence in my will for a year, then that's going to be an immediate post-death interest. This question is where you have a discretionary trust, and within 12 months, the trustees give somebody a right to occupy the property for a year. Well, because of section 144 of the Inheritance Tax Act, which is the section that says anything that happens that changes the terms of a relevant property trust within 2 years of death, it's automatically read back to the date of death. So here we've got a discretionary trust. We've got the trustees within 2 years of death giving somebody a right to occupy the property. That is going to be read back to the date of death. It is going to create an immediate post-death interest. So if that person dies within the 12-month period, that property is part of their estate for IHT purposes. And even when their interest comes to an end, you know, that still has IHT implications because they've had an immediate post-death interest, which has come to an end. So they will be treated as making a transfer of the value of that property. So it's almost certainly something that the trustees don't want to do within 2 years of death, because why would you want to create a retrospective immediate post-death interest for a cohabitee? So what they ought to do in that situation is to allow the beneficiary to occupy on a discretionary basis until the 2-year period has elapsed. And then if they want to, they can give a right to occupy for a fixed period or until it's revoked. Provided you've waited the 2 years, you can't create an immediate post-death interest. And I don't know about you, James, but it's one of the mistakes that I see most often. People not realizing that if they give somebody a right within 2 years, then chances are it's going to be read back under section 144.
Yeah, unfortunately, the firm I'm currently working at, we do a lot of work for the insurers, professional negligence. So there's a nice little dint in my desk where you see things where people, within 2 years, they're giving the rights, and you just think, oh, why?
Why? Yeah.
Why have you done that? And unfortunately, with a lot of the cases that come across my desk, it is really a point of, oh, why? Why have you done that? In some, then unfortunately sometimes they look at the invoice they charged, and you think, "Oh, crikey!" So I agree. It's always better to use the discretion, in that first 2-year period, just to let them live there, and then they can wait and see, really, and at least you clear it from a tax point of view.
Okay, Amanda.
Yeah. Great, thank you. So over to James now. So what can we do to protect ourselves from errors when drafting wills?
Oh,
don't draft any.
Well, that's a good question, because I think there's so many elements here, and I can't possibly cover them all. But I'll run through a couple that immediately spring to mind, and it will relate back to my thoughts about wills. I don't think wills are a cheap commodity. I think the first thing you can do to protect yourself from errors when drafting wills is don't treat wills as a cheap commodity. That's a race to the bottom. You're not valuing the legal advice you are given. And by having that mindset to the preparation of wills, that will change how you deal with them. So I think the first element would be, and this came from personal experience, would be, the first one is, who sees the client? Put the right work in the right hands. And this can come from the use of the client questionnaire that I mentioned before, in that you may get a Mr. Smith phoning you up, and Mrs. Smith phoning you up wanting a will appointment, and they fill in that client questionnaire. If it comes back and you find out that they're a second time around married couple, they're high net worth, you don't want to be giving that work to a newly qualified or a trainee. So it gives you the opportunity to filter so it's the right work in the right hands. It came from a personal experience with me when I was, I think, newly qualified, and the supervising partner was on holiday, and an appointment was put in the diary to see this young lady, and I had no idea who she was. Turned out she was worth about £15 million and had interest in a family business. And when Richard came back, he's sadly no longer with us. He said, "Why on earth did you see her?" Well, it was put in my diary. So no one knew. And we acted for the wider family, but because she got married, no one put 2 and 2 together that it related back to this big family. So if we'd had the will questionnaire, I was completely out of my depth at that time. I should not have seen her. And in the end, Richard saw her again. And the advice I gave was right, but it was the right work in the right hands. So that's the first point. I think then it looks at who is drafting the will. Again, can the work be delegated to someone under supervision, or do you need someone with the experience to see the nuances in how the will is to be prepared? Next one, will precedents. I know when I do some of my talks, and we do really for my own entertainment, I do a straw poll and say, when was the last time you reviewed your will precedents? Starts off 15 years ago. Hands go up. And that can be scary, because there are certain elements, and we review ours, in the 3 and a bit years I've been at BLM, we've reviewed ours twice, and there has been changes, even if they are nuanced changes, especially with regards to, say, the residence mill rate band and flexible life interest trusts, making sure that we can claim the residence mill rate band through that. Keep on top of the precedents. Once you do it once, if you just diarise it, just keep on top of that. You may think that will precedents don't change that much, but it can just be little tweaks. So that's something I think is really important. And the final one for me, and I'm sure Leslie will have other suggestions as well, I think there's such a wide area, would be file closing. So whenever you finish a will file, we've got in place whoever drafts will, if it's one of mine or one of the teams, is always checked over by someone else. And we go through a closing checklist that we've done just to make sure that everything is correct. The will's being checked, it accords with the client's instructions. If there is a joint tenancy, if it's been severed, if we download, you make sure that's been done. Because again, in practice, when on the professional negligence side, that's one that really does annoy me when you say, "Oh, we didn't sever the joint tenancy, we never got the deeds." For £3 or however much it is nowadays, just get a copy of the office copies and have a look. So by having that checklist at the end, that does give you some protection. The last, well, protection for your own peace of mind. And the last one that we do that may be a step too far is we complete a LAW2021 questionnaire at the end of every case. Just in case, having worked at larger law firms, I know the turnover of staff, and it may be that will may not be challenged for 13 years or 15 years. Nowadays, it would be doubtful that solicitors will still be there or the paralegal will still be there. And just by spending 5 minutes or 10 minutes, filling one of those in, you're covering it all off. And if there's any alarm bells at that stage, it's immediately red flagged and you can deal with it. Maybe I'm now a bit too risk averse looking at it from the insurance point of view, but there's been so many times where I feel so sorry for the practitioners who they've done the will in the best intentions and there's errors in the precedent. I remember one, sorry to go on, it had an errant Keith. They copied and pasted a discretionary trust from another will into the will we drafted, and it referred to is for the wife. So it said the discretionary beneficiaries shall include my wife, Keith, and remote to issue. And there was no one called Keith in the family. So unfortunately, I had to go for rectification, and the firm paid for it. So it was one of them ones where you look at and think, all I need to say my children remote to issue, but instead you've got Keith and remote to issue. So I appreciate some of these points sound simple, but I think it's often the simple things that are overlooked.
Couldn't agree more. Can I just ask you about your LAW2021?
Yes.
So do you have a sort of mock-up LAW2021 letter, which you then kind of, put in your bits?
We've got a table that's based from the Law Society practice notes. On the questions that can be asked in LAW2021. Not that we're hoping that we're ever going to get any wills challenged, but again, it's that peace of mind for me, knowing that at each stage we've looked at it and the staff are aware of the questions that can arise as well. Probably through osmosis, that the staff will, the team will go, oh, I need to be aware of this, I need to be aware of that. I appreciate it may be a step too far, but everyone's got their own, level of risk averseness or level of risk that they're entitled to tolerate.
No, I think it's a really good idea. The other thing is, sorry, I'm now asking the questions. But if your firm gets in a LAW2021 letter, and let's say the fee earner has gone, my inclination would be, I would just say, here is what we produced at the time. We're not in a position to answer any further questions. Because I always feel sorry for people who receive one of these kind of, 100 question LAW2021 letters. And my inclination is always, well, I'll tell you what I know, but I'm not necessarily going to answer your 100 questions.
My view would be that the person who prepared the will at that time is the best place to answer. That's why we put it in place, because it's fresh in the memory. Whereas, say for example, if I was contacted about a will I prepared, when I started off in Huddersfield, the name may ring a bell, but I wouldn't be able to say, oh yeah, I remember this and this is what we discussed. So that's why we took the opportunity. Well, I was blessed with the opportunity to start up a new department. And I was like, well, we'll bring this in now because we're starting afresh and everything's fresh in the memory. You can remember the case as it is. You're not then dragging through your memory 10 years later going, oh, I remember Mrs. Smith. She was the one who came in like this, but I can't remember anything much. You can look at your attendance notes, but it won't give you the full picture. At least if you're doing it fresh, it's in your mind and it's less of an onerous job on you than you're doing it 10 years hence.
Yeah. The only things I'd add on, how to avoid negligence, and it's sort of picked up really in what you've said. But I always tell people, make sure that you've seen previous wills, or at the very least discuss what's in it, preferably see them, but at least ask what was in them, because any major deviation, you really want to explore why that deviation is taking place. Document everything, which is really what you've said. And then the other thing about precedents, it just rang a chord with me. it isn't just wills, of course, there's trusts. And recently, there have been several cases where people have simply wanted to do a deed of appointment slightly varying the terms of the will. They've used the precedent that was on the file of the last time that a deed of appointment varying terms was done. And there have been various changes in the law which make it really dangerous to do that. So, you know, don't just blindly follow what happened last time. Because even if it, you know, even if there hasn't been a change in the law, what you might find is that the person got it wrong last time. Yeah. I can also think of cases where people have reused a precedent or a deed of appointment which they've used as a precedent. It was wrong the first time around, so they've now multiplied the error 3 or 4 times. So just really important to check.
And I think as well, people use their old precedents as a bit of a comfort blanket.
Yeah.
You know, they know what they know, and as we all say, change is bad. But at times, I think, you know, one of the challenges I had at a previous role at Slater and Gordon, we'd acquired about 4 firms, all of whom had different precedents. So then it was trying to, you know, amalgamate the drafting style. You know, in the time there, I wouldn't say we got it all 100% perfect, but it was, you know, Pannoni and Partners, there was one of the first, their drafting style was so different to all of the others. So it's, we had to agree on one style because you had people who didn't understand the Pannoni drafting style. Yeah, it's so I think for any firms that are acquiring, you know, one of the things that I think is very important is merging the house precedents so you're all singing from the same hymn sheet.
Yeah.
You know, and that's just a voice of experience. And speaking to other lawyers who have worked in firms that have acquired even smaller practices, you know, oh, this is the style that we use. I think, you know, the problem is if you're doing that and you've got one fee earner who's going ploughing his or her own furrow, that could lead to, you know, problems for the rest of the firm.
The other thing, which is a bit of a hobby horse of mine, is if you're cutting and pasting from one set to another, numbering and sub-numbering, and it often makes it almost impossible to decide what something meant if the numbering suddenly goes awry and you can't tell whether something is a main clause or a sub-clause. So that's, you know, another reason to have a uniform policy.
I think as well, it can be good. Yeah, I'll try and look at things from a practice management point of view. It can be quite good, actually. You know, every few years, just have a sit down with the team and go through it all, because then that does help you find gaps in people's knowledge that, you know, may not come about in the ordinary course of work. And, you know, going back to my own experience, when we've done this, it's been a fantastic way of, you know, I know it's nothing to do with wills. We looked at the full precedents at Slater and Gordon, and we had 2 days locked in a room. But actually, when we came out, we probably did have, in my opinion, we like magpies, we took the best bits for something special. And I do think it's something that's often overlooked because most lawyers, you know, time recording and billing can get the work done. And I think you do need that time to make sure that everything is compliant and right. So that was a very long answer to a very simple question. So I do apologise for that. You can tell it's one of my bugbears when wills go wrong.
No, that's great. Thank you. We've had a question, and someone would like some clarification. I think it's your last question, Leslie. Do we avoid the risk of IPDI tax problems by simply providing the executors may, in their absolute discretion, allow residents in property? Sorry if I'm not quite.
No, that's exactly what it says. I'm reading it. I get the point. It's slightly difficult to answer this question. I mean, if your will creates a trust, which includes a residence, and it says that the executors stroke trustees may allow a beneficiary to occupy the property. At that point, what you've got is a relevant property trust, and the trustees simply have powers to do things. Now, the trustees can proceed in a variety of ways, but one thing that they can do is they can say, we are now exercising our right to give, or we're exercising our discretion and giving this beneficiary a right. Now, as soon as you do that, if you're within 2 years of the death, you're going to create an immediate post-death interest. If the trustees simply say, we have a discretionary power which allows us to let a beneficiary occupy a property at our discretion, they can do that, and that's not going to create an immediate post-death interest. So it's not so much what the will says in connection with a discretionary trust, it's what the trustees do in the 2 years following the death, if that makes sense.
It doesn't to me, but hopefully it does. So the person that's asked the question. So for the next one, we're staying with you again, Leslie. If a cohabitee is given 12 months right of occupation, could a deed of variation be done after the 12 months, but within 2 years of death, to remove the right of occupation and pass the property straight to the children, so that then the RNRB can be claimed retrospectively?
That's quite an interesting question. Basically, if you do a post-death variation within 2 years, it is read back for all inheritance tax purposes. So generally speaking, if you do something within 2 years that gives the residence to the lineal descendants, that's going to get you the residence nil rate band. It would work in this situation. What I think I'm a little bit dubious about is the effect on the person who's given up, well, their right has come to an end. Their 12-month right of residence has ceased. And I suppose you might find that the revenue might argue that they've made a transfer at that point, but I suspect it'll all get swept up in the variation, and the revenue will simply accept that there has been a variation and the property is now going to the lineal descendants and is to be treated as having been left in the will as going to the lineal descendants. So I think the answer to the question is yes, you can do that, and yes, you will get the residence nil rate band. Do you have anything to add?
No, I agree with you there.
No, great. So we're coming back to James now. I think it might lead on from the last thing you were discussing.
Oh God!
What is the most important element of best practice when it comes to wills drafting?
Well, apart from the other points I made, the number one thing for me is an attendance note. Your attendance note are the most important thing. They are your shield because it records exactly what went on. Again, I'm saying this from a practical perspective. When I get the files coming across my desk, and you either see, the instructions being written on a sticky note, on a piece of paper, it's just not good enough. They're not recording everything. So the more detail that you put into the attendance note, the better. And you can structure your attendance notes. So let's say, for example, the Banks and Goods Fellows test, the 4 limbs. There, if you're doing a good attendance note and you're doing your job right in the meeting, you will cover all 4 limbs of that test in the attendance note, and you can go through it step by step. And I think there's nothing wrong at the end of that. At the end of it, say, having considered Mrs. Smith's comprehensive answers to the questions I had asked, I was satisfied that, in my opinion, she had passed all 4 limbs of the Banks and Goodfellows test. And then maybe moving on to the golden rule, despite Mrs. Smith's age and her comprehensive answers to my questions, I was satisfied that a referral to her GP was not required pursuant to the golden rule, because it shows that you are aware of it and it has been considered at that time. There's a recent case, I saw it a couple of weeks ago, where the solicitor was heavily criticised by the judge for the lack of detail in the attendance notes. And I think this all does come back to, I sound like a stuck record, to wills not being treated as a cheap commodity, because you pay for what you get, and if you're doing cheap wills, I would doubt that you're doing the same level of care into your attendance notes that you should be doing, because from a practice side of it, oh, we need to get on to the next one. How many wills are we doing? And it's that never-ending daily churn in practice. However, if you're charging the right fee for the right work, it gives the solicitors, the fee earners, the time to actually do the proper job and make sure everything is properly recorded. And again, by having it in the attendance note, it takes away any ambiguity of, well, why did you do this? Why did you do that? Why didn't you get the deeds, James? Why didn't you do this? So I think it's finding that level of detail, and it's coming back to the point that Leslie said before about the family tree. It's something that I do. I'll get them to draw a family tree. In the days of Zoom and Microsoft Teams, the worst way to do it is use Paint. You can actually draw it on the screen in front of the clients and say, is that correct? And again, the great thing with something like Paint is you can then save that file. And it does look like like my 9-year-old girl's drawn it, but it gets the point across. So I think detailed attendance notes are the most important thing, because if your fee earner's left, fee earner's died, you've still got that evidence of why you advised what you did. That's my impassioned defence of attendance notes. I think they're the most important. Leslie, would you agree with that?
I totally agree. I mean, we're both sounding like stuck records, but it is documenting, what happened, why you made the decision you did, preferably getting the client to confirm that, that your understanding of their instructions are correct. Yeah. The only thing I'd add to what you said is in relation to the golden rule, which is frankly an enormous burden for everybody, but you may have formed the view that your client has got capacity because you've gone through their family tree, their assets, why are they making a new will, their responses are all perfectly normal and rational. But if they're doing what I sometimes call, a red flag will, where they're disinheriting one of their children, you just know that all hell is going to break loose when they die. And there's a case that I've been using recently as an example of good practice. And this was a case where one of the children was being disinherited. And it's obvious that the firm thought, right, we're going to dot every I, we're going to cross every T. And I mean, it's impeccable. And the judge said it's all impeccable. But what they did was, not only did they record in the attendance note of taking instructions, why they thought this woman had capacity, but they also advised her that because it might head off problems, that she might want to consider getting a medical report and also leaving a statement of her reasons for disinheriting her daughter. And she did both of these things. And, the judge had, it didn't stop the daughter challenging the will, but it sure as hell made the judge's job a lot easier.
And then that comes back to the question of, if you're treating that will as a £150 commodity, will you go to that extent? Well, I appreciate that's we're going a bit philosophical here, but I think this is where, as an industry, it's something that we need to look at, because people won't be doing that for £150 or whatever they choose to charge, or your £15 will on wine. But I think it's just record. Record everything.
And the other thing I'd just say is, do you want to be facing on the wrong end of litigation for a fee of £50 or £100? I mean, it's just not reasonable, is it?
Yeah, and sometimes the cases that I do see, you see them where they've tried. We had one recently where they'd done a video recording. They obviously had concerns about Dad, so they recorded him signing the will. So we've got a lovely video of the will being signed and witnessed, but the will itself was awful. So it's kind of like you put in a sticking plaster over a gaping wound. Yes, it's nice we can see him signing it. It's nice that you've explained it to him, but the will itself wasn't fit for purpose. Mm-hmm. And so I do. It is. We've laughed about it, but we think, oh, you can see why you're doing it. We can see you've anticipated the problem, but the issue is here. It's lovely you've got the video, but it's the product, for want of a better expression, that is then wrong. So so for me, my view is document everything. I worked with a solicitor a few years ago, and she did everything, and her attendance notes were a work of art. I was driving along the M62, the sun was shining. That reminded me I needed to go to Morrison's on my way home. I met Mr. Smith. I noticed he had failed to cut his fingernails that week. And they were works of art, and that gave her peace of mind. And I remember some colleagues commenting, saying, "Well, it's a bit too much, isn't it?" But for her, if it made her feel comfortable that she'd done a job properly, fair play to her.
Thank you. So one for Leslie now. So in Vincent versus HMRC, is the RNRB lost because the 3/8 of the house passes via the brother's estate to the niece?
Okay, I probably need to rewind on this one a bit. Vincent is a case where they accidentally created an immediate post-death interest. You had mum who was living in a house with her brother following the death of her husband. She owned 3/8 of the house. Her brother owned 5/8 of the house. Mum died first. In her will, it's pretty clear that what she thought she was doing was leaving her 3/8 of the house to her daughter and expressing a wish that the daughter should allow the brother to carry on living there. Unfortunately, the wording didn't actually do that. The wording said, my trustees are to allow my brother to carry on living there for as long as he wishes. And the revenue picked this up and said that was actually creating a right for the brother to occupy. Therefore, that created an immediate post-death interest. The daughter fought it and said, no, this was just an expression of a wish. But the tribunal said, no, that may have been what she wanted. We can't tell. But the wording clearly says he is to be allowed to live there. That creates an immediate post-death interest. Having created the immediate post-death interest in mum's will, leaving her interest in the house to the brother, even though it eventually passed to her daughter, that is not enough to get the residence nil rate banned. You have to leave the property directly to lineal descendants. So having an intervening immediate post-death interest for the brother lost the residence nil rate band. Had it been necessary. I mean, I suspect in Vincent that mum's estate was actually really very small and inheritance tax had not been on anybody's radar when her will was made. But certainly there was no residence nil rate band in that case.
So we're now going to James. So my firm has been asked to renounce an executorship. Do we have to?
A nice simple question with a nice simple answer. No, you don't have to. There is SRA and Law Society guidance on this. So if you're appointed, you don't have to renounce. However, I think it would be wrong of me not to rephrase the question. You don't have to, but the question should be, should we renounce? And this... why would you, the question I would ask is, why would you want to act for somebody or a family who do not want you to act for them? So if the family comes and say, we don't want you involved, we want you to renounce, there's if you say, no, I'm refusing to renounce, obviously if there's clear reasons, so if there's a trust, there's a family dispute, there may be good reasons for you to say, no, I'm not renouncing. But the question I would look at is, if there's none of those reasons, and you've just been appointed because the client couldn't think of anyone better to, or didn't give it much thought, or you've done a will questionnaire that said, do you want to appoint us as executors, us and someone else, or someone else? I think you should look at, weigh up, what is the chance of a complaint? Because if the family don't want you to act, you insist on acting, and the chances of a complaint and having to deal with a disgruntled family are higher. Dealing with the complaint, the potential of a complaint to the legal ombudsman, I think it's weighing up whether it's worthwhile acting, because in my experience, if the client doesn't want you to act, or the family don't want you to act, it's going to be a difficult estate. No doubt you'll have your costs complained about, because you'll be trying to keep everyone happy. That'll increase the cost. Then they won't be happy with the level of costs. So simple answer is no, you don't have to. Long answer is you don't have to, but consider the guidance by the SRA and the Law Society and think, actually, do we want to act? Should we act? That would be my initial view, because on a daily practical basis, our jobs are hard enough as it is, especially then if you're dealing with people who are disgruntled and don't want you involved.
I totally agree with that. And I mean, you sometimes get the situation where somebody takes instructions for a will. The person says, my children are 2 and 3 and I'm divorced and I haven't got any siblings, and I think it would be a really good idea for you to act. And, they die 30 years later. And everything is left to the son and daughter, who are adults, and they say, well, why are you involved? It's just a matter of divvying it up. That's fine. And I think you'd be mad, frankly, not to renounce in those circumstances. Where I think it's really difficult, and I don't have an answer to this, is where you've had a long discussion with a client who says words to the effect of, my children are a can nightmare. There are 4 of them, they hate each other. They cannot work together under any circumstances. And I really, really want somebody dispassionate and independent involved who will, stand back and see the bigger picture. Will you act? And you foolishly say yes. And then they turn up and they're united in their hatred of you. Yeah. So the 4 of them are saying, we're adults, we can sort this out. If you renounce, they will be at each other's throats. Yeah. Do you care? Or do you? I know I've had this discussion with people, and they felt this sense of moral obligation to the deceased. But hey, he's dead or she's dead. And you are going to be in for, exactly as you've said, a shed load of grief. But that
you'll be treated as the family piñata.
Yeah, it's
and it's working out that balance. Don't get me wrong. I do think if when you have taken instructions, there's valid reasons for you to be appointed, that you do need to record that as a reasoning why, because then it gives you the reasons to go back to the family. And I do think it's a judgment call. Just because you can do something doesn't mean you should do. I think it should be looked at a case-by-case basis. And I think firms who have a blanket policy of we do not renounce, I think that's misdirected.
Oh, yeah.
I have come across cases where that's been the case. And, as one of my colleagues who deals with contentious probate once said to me, why would you want to act for someone who doesn't want you to act for them? And I think that sums it up, because the relationship is always up, and once that relationship's on a bad footing, it's going to be 10 times hard just trying to do your job correctly. You're always on the wrong side of them.
No, that's great. Thank you. I think we might just have time just for one more if we can. I've got one for Leslie here. Mother has a will creating a discretionary trust for family members, including her son, who is severely disabled. Should mother change her will to create a Section 89 for the son?
Okay, so this is talking about Section 89 trusts for a disabled beneficiary which gets special IHT treatment. And looking at the question, mum is still alive, her will has this discretionary trust. There is no simple answer to the question. It depends, I would say, how rich she is. and, you know, what other calls on her estate there are. The big advantage of a Section 89 trust is that once you've created it for a person who is technically disabled within the meaning of the Inheritance Tax Act, it gets specially privileged treatment for IHT purposes. So it's discretionary in form, but it's not taxed like a normal discretionary trust. So you don't have anniversary charges, you don't have exit charges. Because it's discretionary in form, it doesn't prejudice means-tested benefits. So there are a lot of advantages if you're creating a trust of a substantial amount of money. If you simply create a discretionary trust with your disabled beneficiary in the class, then you're going to be paying quite a lot in inheritance tax as you go along. If you create a Section 89 trust, discretionary in form, but not subject to those IHT charges. So if your trust is of an amount which is sufficient to, you know, be attracting hefty IHT charges, you would prefer it to be a Section 89 trust. But if you're talking about a smaller amount where either there aren't going to be any IHT charges because the amount involved is so small, or any charges that there are going to be very small because of the level of funds within that trust, you might actually prefer to go for a discretionary trust, not a Section 89 trust, because a Section 89 trust is not very flexible. You can only use the funds in the trust, subject to very, very small exceptions, for the disabled beneficiary while the disabled beneficiary is alive. So if I've got 4 children and I basically want to give them in my will 200,000 each, I might think to myself that the trust that I create for the disabled beneficiary, it might as well be a discretionary trust because there really isn't going to be very much IHT involved at all. And it might be that that beneficiary doesn't need anything from the trust because they're covered by means-tested benefits. And it would be very annoying if you've got 200,000 locked up in that trust. One of the other children is in urgent need of some funds. You can't make anything available because it's a Section 89 trust. But if you were settling, I don't know, 500,000 or 1 million, you definitely want a Section 89 trust because that would dramatically reduce the amount of IHT. So it's a balancing up. What is most important to me? Is it flexibility? If so, go for the discretionary trust. Is it saving IHT? If so, go for the Section 89 trust.
And I suppose to square the circle on that, that's when you're recording your advice in a full and detailed attendance note where you've given the client both options, so they've therefore made the informed choice.
Yeah, absolutely.
Because sometimes for some clients, the tax implications, aren't important for them.
Yeah.
They're happy to pay the tax for the flexibility.
Yes.
So again, I know it's kind of shoehorning a bit back to will drafting and protection, but I think something like that, in that case, the example we just used there is really important to show what advice you've given so the client has made the informed choice on that decision, because you can see that worst case scenario, the family coming back and say, you've put in Section 89, but we need the money now.
Mm.
So
I mean, I think with that, you'd always put that advice into a letter to the client so that the client can sit down and think about it and, if necessary, discuss it with other people. It's not something that you'd ever just do orally, even if you did make a really detailed attendance note, because, how is the client going to keep all that in their head? So, a fully...
It belts and braces.
Yeah.
Belts and braces, yeah.
Okay, I think we're done on that one.
So yes, unfortunately, that is all we have time for today. Thank you for attending Law 2021 Online Rules and Probate Shape the Debate, hosted by the Solicitors Group. Thank you to our expert speakers, Professor Leslie King and James Berrowford. Don't forget to join the Solicitors Group's Law 2021 online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning of the session, a recording of today's live Q&A will be sent out by email within the next few days, so keep an eye out for that. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinars you purchased. There is still time to buy the complete event, including a recording of this live session, if you haven't already done so. To book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue worth £35 plus VAT. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD certificate. So all that's left to do is say thank you again for joining, and thank you to our speakers, and we hope you have a great day. Goodbye.
Thank you. Bye.
Thank you.